120 words per minute. Get ready. Start. As stated earlier, the said memo was received on 30/3/2017 by the Assistant District Election Officer itself, and on receipt thereof, the Assistant District Election Officer dispatched the notices by registered post at 6 p.m. onwards on the same day, for which he has relied on the receipts of the post office that are in the record placed before the court. He also submits that the videography of 27/3/2017 contained in a compact disc CD is also available on record. He further submits that so far as the district magistrate is concerned, he had completed all formalities to ensure that the notices were dispatched and received by the members for the holding of the meeting, and is made known to them. Apart from this, he has urged that it is a matter of fact that the said proceedings were also made known to the public at large through newspaper reports, and at the same time there is no error in the procedure having been followed, and any lapse on the part of the Jilla Panchayat official in not passing the notice would not invalidate the convening of the meeting. He has also adopted the legal submissions advanced by Sri Anil Tiwari, Learned Senior Counsel for the intervener, and has relied on the same decisions. Sri Anil Tiwari, Learned Senior Counsel, appearing for the intervener Sri Prabhat Kumar at the rate of Prabhat Kumar Gupta, has urged that the full bench decision in the case of Srimati Sheila Devi Supra also spells out that the district magistrate is not required to conduct any detailed inquiry or investigation to assess the evidentiary value of any incident in an elaborate manner. He has simply to satisfy as to whether the requirements of Section 28 are fulfilled or not, and to comply with the mandatory part of the procedure prescribed to ensure that there is substantial compliance of the procedure prescribed in law, either with regard to receiving of the notice of no confidence motion or the dispatch of the notice for convening of the meeting. He submits that both these conditions are satisfied in the present case, and he is, with the aid of the full bench decision in the case of Vikas Trivedi versus State of UP and others 2013 to UPLBEC 1193, urges that even if some of the procedural conditions under the notification of 1962 have not been adhered to strictly, the same would not invalidate the meeting, as the said provisions are directory. To substantiate his submissions, he has relied on the 5 judges full bench decision in the case of Sardar Gyan Singh versus District Magistrate Gonda and others, AIR 1975, all 315, followed by the division bench judgment in the case of Jivendra Nath Kaul versus State of UP and others 1991, 9 LCD 186, and Brijendra Bahadur versus Singh versus District Magistrate Gonda and others 1991, 9 LCD 606. He submits that affixation and posting of notice is not mandatory, and even if the notice was not posted on the notice board, all the members have been duly notified and are under a valid notice to attend the meeting, hence the same would not vitiate the convening of the meeting. He submits that no member has come forward complaining of not having been informed of the date, time, and place of the holding of the meeting, and in as such a situation, the dispatch of notice on 30/3/2017 fulfills the requirement of 15 days clear notice, excluding the date of dispatch and the date of holding of the meeting. Stop.